Welcome everyone, and thank you for calling into our press conference today. We're here to talk about this morning's hearing in Cabot versus Scroggins, which was held at the Susquehanna County Courthouse in Montrose, Pennsylvania. The hearing lasted for about an hour, and the focus of the hearing was whether the judge should lift or modify the injunction against Vera Scroggins. The injunction, which has been in place since October, prohibits Vera from going on not only Cabot-owned land, but also Cabot-leased land, where Cabot leases only the subsurface mineral rights, so that Vera has effectively been prohibited from going to her grocery store, a number of businesses in town, her local hospital, and some of her friends' home. Now, Cabot came into the hearing saying that they were willing to modify it to take away some of the more onerous restrictions, but they proposed instead that Vera needs to stay 150 feet away from certain areas of operations and 500 feet away from others. And we made clear to them and to the judge that we thought that restriction was arbitrary, overly broad, and restricted not only Vera's freedoms of speech and movement, but also the rights of the landowners who might invite her onto those portions of the land where Cabot was not drilling but might be within 150 or 500 feet of their well site. We found the judge really thoughtful, receptive to our arguments, and as well as to some of Cabot's, and I think he asked insightful questions and really seemed to understand what was at stake and the issues in the case. He asked both sides for proposed orders, but did not rule definitively from the bench. I wouldn't be surprised to see him rule sometime later in the week, but both parties were to submit proposed orders to him by the end of the day, and then I imagine he'll pick one. So it seems likely at this point that the injunction will be narrowed in some manner, and the major question is, will it include the onerous buffer zones that Cabot is now proposing, or something more narrow? We proposed instead that the injunction, if there must be one, be limited to Cabot's well pads, to blocking its access roads, and to the properties that Cabot actually owns, as opposed to merely leases. So that's a summary of the of what happened at the hearing. There was also a brief discussion of a discovery motion to compel. So with that, I'll open it up for questions. I have here with me Vera Scroggins, of course, the defendant in the case, and my name is Scott Michelman, Micheelman, attorney with Public Citizen. And we may also have joining us, and I'll ask if he's on the phone yet, Vic Walczak, the legal director of the ACLU of Pennsylvania. Vic, you there?
Yep. I'm here. Hi, folks. Sorry, I'm on the injured reserve list, so sitting on my couch. Sorry, I can't be there in Montrose. Hi, Vera.
Hi, Vic.
And Vic Walczak, Walczak is spelled Walczak, and he's the ACLU of Pennsylvania legal director. I'm a staff attorney with Public Citizen. Vera's our defendant, and we are open for questions.
Actually, what's the name of that spelling of the Susquehanna County judge who heard the case?
Sure. His name was, Kenneth Seamans. That is Seamans. And the court is the Susquehanna County Court of Common Pleas, located in Montrose, Pennsylvania.
Can I just ask, is it my understanding then that you've had no decision from the judge today?
That's correct.
And you don't know when you will have a decision?
That's correct, but I wouldn't be surprised to see it sometime this week. He sounded like he wanted the proposed orders today, so I think he'll make a decision, and we hope he will, because until then, Vera is still under the onerous restrictions of the October injunction, barring her from large swaths of Susquehanna County.
And did you say that you are proposing that the injunction, if there needs to be one, would be limited to
Cabot well pads, the properties that Cabot actually owns, and then you said something about access roads. Can you repeat that?
Sure. Cabot has expressed concern that it needs access to its roads up to its well pads, and that on a number of occasions it makes allegations about those roads being blocked. And we said we would be willing to accept an injunction that that prohibits blocking those roads, essentially parking or stopping a vehicle on or within a certain number of feet of the entrances to those roads to preserve Cabot's access. So we, throughout the hearing, we were trying as best we could to take a practical approach to solving the problem of accommodating what legitimate interest Cabot was putting forward without impeding Vera Scroggins' First Amendment rights to protest and to document, as a citizen journalist, what's going on in her home community.
Had you had discussions with Cabot before getting in the courtroom without potentially compromising here?
I'm sorry, could you repeat the beginning of that question?
Did you have any discussions with Cabot in advance of the hearing about reaching a resolution on your own?
Yes, we did. They offered. They made the offer involving the 150-foot buffer zones prior to the hearing. We made clear to them that that was too restrictive, and we would be willing to negotiate. And we asked for a few more details about some of their specific concerns so that we could try to reach a resolution. But they indicated that they were no longer interested in speaking with us and would see us at the hearing, which they did.
And explain, you kind of dropped out for a second. They won.
So they had proposed to us an injunction that lifted some of the restrictions on Vera in terms of unactive sites. So that's the public properties, the businesses, the hospital, which is something that we're very interested in, obviously. But they would replace that with these large 150-foot buffer zones that would make it very difficult for Vera to get close enough to their sites, even on public roads, to videotape or to protest, and could put her in violation of the injunction just for driving by their sites. So that was unacceptable to us, and we made clear that we would like to negotiate further, but they weren't interested in that.
But you mentioned 150 feet away from some sites and 500 feet away from others. So what site would fall in the 150-foot range and which one in the 500-foot range?
So today, for the first time in court, they made a proposal involving 500 feet. I was not. They made it so quickly, and it wasn't in writing anywhere, that I was not 100% sure I understood. But it sounded like they were saying some of their active sites would be 500 in some stages, and maybe in later stages it would be 150.
Foot buffer zone. If she's on public property, is there a direct First Amendment violation if she's not posing any threat or has not posed any threat to any of the safety of the workers?
There is, because it's well established that the First Amendment protects not only protest activities but also the right to document, and that injunctions that restrict the ability of a protester must burden no more speech than necessary, and certainly preventing someone from being on a public road and filming what they see burdens more speech than necessary to protect whatever safety or property interest Cabot has.
Can you talk about how this has impacted you, this injunction has impacted you over these last 5 months?
Well, one of the impacts that I can think of right now also is that it's actually done something to my personal image. When people hear about an injunction put on somebody, I mean, I've never heard of that in my life before, but some people are thinking, like, what could have she done? What horrible things could this person have done? What kind of a danger is she that she deserves or receives such an injunction that's so extensive and so broad? So that is disturbing, to be able to live under that and the implications of that. Besides making it more difficult for me to visit the families that are impacted, who have water contamination, who have all those issues which I show on my tours on a regular basis, on an almost weekly basis, and I can't go into their homes and talk to them and bring the people and hang out with them. And I had to do the tours through the winter, and I stayed on the edge of the road while I showed some of this, what was going on. Some of the people went into the homes without me, and I was staying outside, and I had to, and it was freezing temperatures, and I told everybody, please don't go more than 15 minutes, 20 minutes, because, I got to keep turning this car on and off and staying warm, and I'm waiting for you to come out. And sometimes they still stayed longer. They were there like a half hour. Media came in there, talked to the people, who have the water contamination, and it was difficult. And plus trying to figure out, like, where can I stand? Where can I walk? I've never had to think about that. I used to just walk freely. If there's a no trespassing sign, I would notice that. I would honor that. And now I have to just watch everything, count how many feet can I go off the road. Maybe I can go 2 or 3 feet. Where can I park the car? They're watching me. They're taking pictures. They're following me. So it's not a pleasant thing to endure. Plus, even one of my grandkids complained. I have 2 grandchildren, 9 and 10, and the 10-year-old said to me, can we go out to eat to this particular restaurant? And she heard about this ban. And I said, and she was worried. She says, man, can we go to this restaurant? We're going to have a problem. And I said, oh, no, that one's okay. That one's not on the banned area. And then she was like relieved. She says, oh, good, we can go. But she was worried, like, maybe I can't go everywhere with my grandmother. And that was like bizarre for me to experience and disturbing. So it's kind of a strange thing to now have this over your head. And now they're talking about 150 feet, and they want to, from the sites, 500 feet from the sites. Now, how am I supposed to know this? I'm supposed to measure this out. I have to keep watching where I walk. I mean, the whole thing is a bizarre thing to me. Thank you.
And if I could, if I could ask Vic from the ACLU to comment, is this something in your experience that's common here in Pennsylvania? These types of broad injunctions.
These types of injunctions are extremely rare. You think about, somebody was asking about 150 feet or 500 feet. To give some context to this, when the area where injunctions are much more common would be, say, in abortion clinic protests. And typically what the courts talk about there is, 8 feet or 15 feet or 30 feet. When you're talking 150 feet, this is huge because you really are talking about restrictions on a person's ability to speak, to express themselves, and, as Scott says, to gather information, which all of you journalists will know and appreciate is protected by the First Amendment. But let me just say something briefly about why the ACLU is involved in this case and why we think this is so important. People like Vera Scroggins can be called citizen activists. They can be called gadflies. Whatever you call them, they are vital in our democracy, especially when you're talking about a situation like fracking in Pennsylvania. I think the jury's out. People support it, don't support it. But there is little known about the effects of fracking, and the industry has been incredibly secretive, using all sorts of confidentiality orders to prevent the public from finding out what the real effects are. Somebody like Vera is indispensable to trying to monitor what is going on up in Susquehanna County. And when you get an injunction of the type that Cabot secured last October, you're essentially putting her out of business. You are preventing her from being able to engage in this timeless function of citizen advocate, citizen activist, and that's why the ACLU is involved in this case. That injunction, to the extent that one is necessary, must be significantly tailored in a way that does not affect either Vera's constitutional rights or the rights of other property owners who may want Vera to come help them out and make sure that Cabot's doing everything on the up and up.
Can I just clarify, what's the difference, of all the, they've leased such huge amounts of the county, so which sites would be a 150-foot ban, which sites would be a 300-foot ban? Were there any criteria, or were they just sort of throwing out this idea of the cord and the various sizes?
as best I understood them, I think it would depend on whether the well site was in active use or not. But the 500 foot was something they threw out sort of at the end of the hearing. It was a very strange moment when they'd been talking about 150 feet and given the judge and us written proposals talking about 150 feet, and then 500 feet came up near the end, and they said, well, some sites will have to be 500 because they're active. But what I think is clear is, as Vic described, this would be an injunction of unprecedented breadth if there were a buffer zone. Now, obviously, we would be very pleased for Vera to be able to go to the businesses, to her friends' homes, and some of the other places, but to replace those restrictions with large, 150 feet is half a football field away.
But I understand, but are they saying that we would only, so it would be only the active, the sites that we're now producing, or what would be the criteria?
I think
the 150 feet.
That was not entirely clear to me in court today. I think they were saying that they wanted 500 feet from well sites that they were actively operating on, but they didn't define that, and then 150 feet from access roads and sites that were in production or reclaimed. But I was not totally clear, and hopefully the judge will reject out of hand such an extremely large zone that would prevent Vera. Talk about putting Vera out of business in terms of sending her away, of really banishing her away from these sites so that she can't see what's going on.
But this should be clarified by the end of the day, correct? Because Cabot has to submit the proposed order.
It's not clear to me whether they brought a proposed order to the hearing. It is not clear to me whether they will be supplementing that with a clearer proposed order, or if they were hoping that their oral modification to add the 500 feet, which was not in the written documentation today, would be sufficient. We will be faxing the judge by the end of the day, as he requested, a proposed order that provides for a much narrower injunction in line with Vera's constitutional rights.
Okay, so and what's the ratio between frac sites and so basically, and the much larger share of land that they've actually leased? How many?
You mean how many
of that 40%? How many active frac sites would that mean?
Well, I think we have about 400 frac sites in Susquehanna County. So they are like 40%. So I don't know. We'd have to guess. We have to look up on maybe one of the sites, but maybe 40% of that. What would that be? 40% of 400.
I'm not clear if it means wells that are producing or just in the period while they're fracking them.
As far as what?
As far as the 150 versus the 500. Yeah, that was not terribly clear to me either. And I think I think we would have asked for more clarification on that if the judge had seemed interested in it. It was sort of their tossing off an additional condition sort of at the end of the hearing. I didn't get the sense the judge was terribly interested. At least I hope he wasn't. And I guess we'll have to see about that. As far as how many sites are covered, it's important to recognize that Cabot isn't the only gas company operating in Susquehanna County, but it is either the largest or one of the largest.
It's the largest one. So let's say they have about 160. I have somebody who just wrote something. So I was 160 sites that they have at this point in our county.
So it's vital that citizen journalists like
Vera, that means active sites?
That means, yes, active sites, either in various stages of development or production.
And it's vitally important that citizen journalists like Vera are able to document what's going on there so people can realize what's happening in their community. And for those communities elsewhere who might be considering permitting this type of fracking activity, that they know what the costs are.
Did the judge get into the issue of all of the terms of of Cabot's the wording of Cabot's lease agreements. That these leasehold agreements actually gave them the right to make any kinds of conditions.
So what's interesting is Cabot is relying entirely on Pennsylvania property law for that. They are not claiming. They seem to have disclaimed a right based on the leases themselves to exclude people from the properties in question. They're just talking about what rights they have as a subsurface mineral lessee under Pennsylvania law. Now the problem for them is that though that law only gives them the right to the areas that are necessary for their operations. So if they're developing 5 acres for drilling on a 10-acre piece of property, they don't have any right to those other 5 acres, any right to say who comes on those 5 acres, any right to prevent the owner from going right up to the edge of those other 5 acres and taking a look at what they're doing, or to invite Vera to come along with him and take a look.
But the judge didn't get into that.
The judge did get into that to the extent that Cabot Cabot disclaimed reliance on the leases. We actually the second motion that was argued concerned discovery. Cabot has refused to produce the leases, and Cabot's basically arguing, well, they're irrelevant. We don't need them. The Pennsylvania property law supports us, and we don't think Pennsylvania property law gives them nearly as many rights as they seem to think they do. And I mean, Pennsylvania property law says nothing about 150-foot buffer zones or any kind of buffer zone. They only get what is necessary for their operations, and other than that, it's the rights of the owner, or in some cases, I mean, these 150-foot buffer zones would go onto public property, so it'd be public public roads that would be impacted, and we made that point to the judge.
Scott, this is Vic. Let me just add that we have seen a handful of the leases that Cabot signed, and none of them have language in there that would give Cabot the kind of authority to exclude people from sort of not parts of the property that are not necessary for drilling. And if you think about it, how many landowners would actually cede that kind of authority by saying to Cabot, oh, yeah, you can decide who's going to come and visit our homes, and it's not going to happen. So that authority is not in the leases, at least the ones we've seen. We assume those are reflective of all the other leases that are out there, and so it really is just a matter of trying to use state law to argue for greater rights.
Thank you.
The injunction, as it stands now, already bars her from those properties, right? I mean, like, she couldn't go into a house of somebody who had leased their land to Cabot. Is that right?
That's correct, and that's one of the reasons we've argued that the current injunction is too broad, because it restricts both Vera's rights and the rights of the landowner.
On the original injunction, does it seem logical? Why would a judge who's trained in constitutional law allow that full injunction that was requested by Cabot, and then now is going to consider for maybe 3 or 4 days the First Amendment implications of the buffer zone? Does this seem unusual for a common pleas judge to take that much time, or to give that much credibility to Cabot?
Well, I think that maybe Vic can speak to what's common practice in Pennsylvania courts, but I will say that to me, the fact that the judge granted the injunction initially highlights the importance of counsel, because Vera had very little notice of the original hearing, went there without an attorney, and so there really wasn't anyone to present the other side, to raise the constitutional arguments, to point out the limits of Cabot's rights under Pennsylvania property law. Vic, can you speak to common pleas practice?
Yeah, I think you preface your question by saying trained in constitutional law, and this judge has been on the bench a long time. We think he's apparently close to retirement. So he was in law school studying constitutional law several decades ago, and And frankly, most practitioners and most judges do not have a lot of experience with the Constitution, including the First Amendment. We talked earlier about how rare these kind of injunctions on First Amendment activities are in the state. So it's possible and even likely that the judge has never entertained something like this. And what often happens in cases, whether it's in the First Amendment constitutional context or otherwise, is that when you have a party that goes in with counsel, they have a distinct, decided advantage. And it's not unusual for a judge to simply rely on counsel, assuming that they are not overreaching, and give them pretty much everything they want. And it appears that that happened here. You know, it's not anything malicious on the part of the judge. It's just, you know, it was an order presented to him. He gave it probably relatively short consideration and issued the requested injunction requested by lawyers licensed to practice in the state of Pennsylvania. And now that there is a real fight and shortcomings of that injunction have been brought to his attention, hopefully he will substantially narrow the injunction so that it conforms with the Constitution.
Why would he not have granted the continuance asked by Vera at the first hearing?
You have to ask him.
Yeah, the judge's stated reason on the record was that she didn't give 24 hours notice that she wanted it. And
Is that common for a judge to require a 24-hour notice, even though she did not have more than 3 days, including a weekend, to find a lawyer?
Yeah, I think it's within the judge's discretion to make that ruling. You know, would have hoped that he would have ruled otherwise, but I don't think it would be considered an abuse of discretion by an appellate court.
Is this also the kind of injunction that if the buffer zone remains, that would be taken directly to U.S. District Court?
So to be clear, this is in Pennsylvania courts, and under federalism principles, our appeal would lie within the Pennsylvania court system.
I mean, it would go to the Pennsylvania Superior Court.
Okay, but not to a federal court.
It's
right.
Unlikely, I think, to end up in federal court for a number of reasons that Scott mentioned. Yeah, I mean, this is a battle that's likely to be fought out in the Pennsylvania state court system.
Other questions?
Yeah. How in the world would this work?
I'm sorry. Can you repeat it a little louder? I don't think most of us were able to hear you.
Yeah. How would this injunction be enforced? Or how is it? Is it formal or is it informal?
It would be enforced by, the question was how the injunction would be enforced. It would be enforced by contempt sanctions. So if Vera were found to be violating it, or if Cabot thought she was, they could come to the judge and ask for penalties to be imposed because she had violated the injunction. So what's powerful about an injunction and why it needs to be used sparingly is because it allows, it sort of sets up a process already in place for the party that got it, here Cabot, to go to the judge and ask for penalties without having to start a whole new lawsuit, obtain counsel. It's just a streamlined way for them to enforce something. And when it's this broad, it's very scary for somebody like Vera who's under these provisions and under the threat of serious sanctions.
But what might those penalties look like?
Sometimes fines are imposed for violating injunctions. Sometimes people are incarcerated for violating them. It's possible. And I believe, I would have to check the transcript to be 100% sure, but I believe incarceration was mentioned as a possible sanction in the original hearing back in October. But I would have to check that.
Can you guys send around the actual text of the injunction itself?
From October?
Yeah, I mean, it's not, obviously it's not online, the county court matter.
Right. Angela, if we send that to you, is that something you can distribute to the list?
Yeah, certainly. And if folks want to give me your email addresses, I'll make sure that you get it. And also, what we could do is post that online too, right, Scott?
That's right. We could post it at our website, citizen.org, where you can read our brief and just see a summary of the case.
Right.
Well, why don't we post it? Why don't we post it there?
Okay, that sounds good. And if folks in the meantime want to give me your email address, I can make sure you get it as soon as I get it.
Other questions? I'm sorry. It's a little hard to hear, and there's a dog barking. Could somebody mute the dog?
And does the dog have any questions? I'd like to hear the dog.
Could you understand it? I couldn't.
No, just a little bit louder and maybe slower.
Oh yes, yes, there was. Vera, do you want to speak?
Yeah, it was great.
The
courtroom seemed like it was just about full, and it was a nice surprise. And we had, of course, pro-gas people that came in. A lot of them from New York, and they were on one side of the courtroom. And we had a lot of people that were supporting me. So it was wonderful to see. And we had a lot of media, which was also the most I've ever seen, actually, in our county concerning a fracking issue. We had the most media in one spot concerning fracking issues. So that was wonderful and exciting.
The sheriff said it was the largest crowd they've ever had at the courthouse.
Really?
Including murder trials.
Wow, they said the sheriff, looks like we just heard, the sheriff said this was the largest crowd we had in the courthouse, including the murder trials that we've had, which also attracts a lot of people. So this was the largest crowd we ever had. Wow, that's like amazing. Thank you, everybody.
Any further questions? Okay. Thank you very much. Once again, the Scroggins is His last name is Public Citizen. Any final business other than to get to So that should be up on our website as soon as Angela can get it there. Okay. Thank you very much, everyone.
Thank you, everyone, and my love to the dog.